Good evening, this is Laws 11057, Introduction to Law. It's week 8. We have a number of things that we need to discuss tonight. I'm going to commence by talking about writing well, and in that regard I'm very keen to ensure that you understand the importance of submitting your work on time. I know that sounds a bit basic. You've been collectively been doing a wonderful job in submitting work on time. But practice as a lawyer is all about meeting deadlines, and a document, no matter how well it's written, may be of absolutely no use if it's not submitted on time. So please bear that in mind. And sometimes you need to compromise and present something that may not be quite there, but at least it's on time. I propose to share the screen and go to my desktop. Number 1, hopefully you can now see what I call my sample document. Please let me know if that's not the case. I've revised the sample document. I'm not sure who it was that pointed this out, but I actually had the referencing prepared incorrectly on the inside rather than the outside of the full stop. So whoever that was, thank you very much. So you'll see there, I've corrected it now, and the reference comes in after the full stop, as it should be. I take it that most of you, if not all of you, have looked at the sample document. There are a few different versions of this, so I do update it from time to time. Sometimes it's only because I like the look of the fresh appearance. So my personal preference is for something that's simple, something that's professional, use footnotes, and when you're quoting material, you should indent and drop a line and reduce the font by 1 point. So you'll see there an example of what I mean by something which is indented and a lower point. Make sure that the document is consistent in the use of the headings, the font. Make sure that there's a consistent uniform gap between paragraphs, and when you're making reference to legislation or case law, please type it in italics. Other than that, make sure the document is paginated and internally consistent. Use short sentences and generally quite short paragraphs as well. So for those of you that haven't had a look at my sample document as it appears now, I urge you to do so. We'll just show you a few things that may be of use. So if we go to File, Options, Proofing, you'll see that we have the opportunity to set out the document in terms of what we want to chase, and there's certain things to do with grammar and style. I think I've got them all ticked except use of the first person. If we then go OK and come back here, we can check the grammar and style or the grammar. My preference is grammar and style. So let's recheck this document and see what it comes up with. So you'll see there that the blue line, the dreaded blue line, has come in, and it says that it would like it reworded. I think the problem there is that I've got the footnote in an odd place, and that's why it's identified. Word has identified that as being a bit odd. For the rest of it, it's fine. You'll see that from the quote of Lord Denning, there are a few things that Microsoft would like to change. There's an odd passive voice thrown into that commentary as well. But it'll come as no surprise that what I've written is consistent with where it was, because I've been through this document a few times. It's identified here the use of a passive sentence rather than active. So the accused hit the victim is the preferred active style, as opposed to the victim was hit by the accused. That's passive, that's to be discouraged, and Word has picked it up. It says, please consider revising that passive voice. All right, so that's pretty simple. And that's the proofing option, which I commend to you. Other than that, the review, spelling and grammar will identify things in similar vein. So we'll just ignore that. Passive voice, we'll ignore this one as well. Ignore what changes Word would like to recommend to Lord Denning. And eventually, we should get to the end of the process. It says, right, we're good to go. And I've added in a thing called readability statistics. This is important, I think, because it shows you in summary form the number of passive, or the percentage of passive sentences in your document, and also the reading ease and the grade level. Now, non-surprisingly, they're good numbers. And I say good because this is regarded as, or the program regards this as a highly readable document. The grade level of 6.5 means that someone in Year 7 should be able to read it comfortably. And it's a high reading, the higher the number of reading ease, the better, and the lower the number of passive sentences, the better. So I'd commend the use of readability statistics if you want to check on how you're going in terms of readability. Obviously, law is difficult in terms of its content, and sometimes it's very difficult to avoid a readability score of, say, 11 or 12 because we're using difficult technical words. But generally speaking, try and keep it simple is the preferred option these days. Right, I'm just going to get a blank document now and just extract something from the Moodle front page to do with the Student Success Centre. And I'm just in the process now of cutting and pasting that. You should be able to see a blank document. Please let me know if that's not the case. I'll simply paste, keep in the text. And I am a fan of using title. You can use heading if you wish. So if we go to extract that heading, if you like, use title, and it will then use the theme or the style built into the program. You can right-click, modify that, reduce the font, do whatever else you like, and that will then automatically change it. You'll see here that there are a number of things that Word doesn't like. And again, you can go through that same process of options, proofing, recheck the document, and it will come up with some ideas and some suggestions. And generally speaking, it's probably a good idea to accept the recommendations, not blindly, consider them, of course, but I think what I'm really suggesting is that there's going to be a way of the world, and having a consistent way of describing your material is probably the preferred option. So, and then of course we've got the issue of readability statistics. We go into spelling and grammar, and you'll see there that the numbers are not as good as the other document. There's more passive sentences, it's not as easy to read, and the grade level is higher. So that's just a short demonstration in relation to my preference. So generally speaking, use shorter sentences, avoid passive sentences. Also, try to avoid finishing a sentence with a preposition. So prepositions are so prepositions are words that introduce information to a reader, and it's not something that you would normally finish a sentence with. And I've just done that. So a preposition might be in or to, or it might be from or for or with. It's just a question, where did I go for options for words? I'll just share the screen again. It's the file, okay, top left-hand side of your document. I haven't shared the screen at this stage. The top left-hand side of the document, and go to File, and drop down to Options, and then Proofing is up on the left-hand side. Hopefully you've been able to follow that, and then recheck the document. Okay. All right, so coming back to prepositions, we don't want to finish a sentence using the words in or to or from or for or with. And part of the reason for that is that we want to provide further information. So a preposition is something that introduces information to the reader. A prepositional phrase is one where there is a phrase introducing more information for the benefit of the reader. So, for example, the DVD is in the brief. So that's a prepositional phrase. The word in is the preposition and the word brief is the object of that preposition. You'll see that by adding the prepositional phrase, the reader will better understand the true position. So let's take an example. My mother cried, or sorry, my client's mother cried. Becomes, my client's mother cried with tears of joy. So by adding that prepositional phrase, the reader better understands the true position. So don't finish a sentence with a preposition, but use the preposition to add further information. I've just used the word don't, which leads me to my next point, and that is informal legal writing. Avoid the use of abbreviated language. Always write do not instead of don't. Now, you might think, well, I'm here to inviting you to simplify, but there's a degree of formality that we like to maintain as well. And simplify your language wherever you can. For example, instead of saying, I read through it, just said, I read it. You know, the word through is an extra word that doesn't add anything. Take care with the possessive apostrophe, and unless you're using a heading or writing a heading, you should write a complete sentence. So avoid being too shorthand. And now, just a small thing, avoid, just there's a difference between which and that. Now, I'll just share the screen to show you some information. I've made some notes to this effect. So I hope you're not finding this too basic, but it is important to, I suppose, ensure that you have some of these habits well ingrained into your thought process. So I'm just going to share the screen now and cut and paste some information. Sorry, the program never works as fast as I'd like it to. We're getting there. We're getting there. And now the share screen. All right, so the first example, hopefully you can see that, is the students which graduate from CQU are talented, or the students that graduate from CQU are talented. The preferred option is the second sentence. Word will tell you that. And if we right-click over the first sentence, you'll see that Word provides two alternatives. The first is the students, comma, which graduate from CQU are talented. That's fine. You can do that. Or the students that graduate from CQU are talented. So that one's equally acceptable. So you can remedy the first sentence by changing the word from which. From which. That's the problem with that's the problem with my voice recognition. Sometimes I don't pick up a mistake. From which to that, or by introducing commas. I did do this quickly. I just did this a moment ago. I'm sorry. After the word student and CQU. So if you add the commas, it means that the phrase adds information. If you change the word, it means that the sentence now limits the proposition to a limited group of students and not all students. So let's look at the first one. If you add the commas and make it the students which graduate from CQU are talented, we're adding information. And if we use the second sentence, we're limiting the statement only to those students that graduate from CQU. I know I'm perhaps talking in semantics, but the point that I guess I'm making is understand, just in brief fashion, the difference between which and that in the context of your legal writing. Are there any questions? And that will end the spelling. This is the English class. Okay, most of you are doing very well in terms of pinpoint referencing. Very pleased about that. And there are a number of different ways to pinpoint reference, but look, in essence, I don't think you need to be too worried about it. What we mean by pinpoint referencing is if you are making reference to a case, and it may be that the case commences at page 399, for example, what you then do is say, well, the particular sentence that I'm quoting from is at page 412. So it would be the case citation 399 at 412. So that's what I mean by the pinpoint reference. There's different ways of doing it. Sometimes it can be a comma and then the next and the actual pinpoint, or it can be at and then the page number, or at and the page number in round brackets, or it might be the use of square brackets to show the pinpoint referencing. The whole lot of different technical rules that go with that. The Australian Guide to Legal Research, the Practical Guide to Legal Research, does have some commentary in relation to the issue. There's another little one. This is a good book from LexisNexis, Legal Referencing, that has some information in it as well. And the Australian Guide to Legal Citations has some information. But to be honest, I don't think there are too many judges that will be overly concerned about whether you've used the square brackets or you've used round brackets. The main thing is to identify exactly where it is so that the judge or the magistrate can actually go to the source material and find it easily. That's the important thing about pinpoint referencing. When it comes to referencing, use the footnotes. You're all doing it very well now. And I recommend using it, have a gap between the reference number and the commentary at the bottom of the page. And that's in my sample document. Okay, now I had a question about voice recognition software, and I think you may have seen the video that I use. The one I'm not here to endorse a particular brand, but the one I use is Dragon. I find it very good. And to be honest, I haven't used any other brand, although many years ago when voice recognition software was coming onto the market, I spent many hours trying to get it to work, and in the end I couldn't. But I came back to voice recognition maybe 5 years ago, and pretty much straight out of the box it worked for me. Many of my colleagues struggle with it and have abandoned it, and it may be that the way in which I speak is better suited to voice recognition. So it's perhaps a matter of different people have different opportunities to make it work. I find it an excellent way of practicing. For example, today I had a barrister, and we had the conference in my room. Client was there. Most of the discussion was between the barrister and the client, and I was in the at my desktop, immediately just on the other side of the desk, and I just hide my voice and I lower the tone so that they can hear me whispering, but they can't really, it's not interfering with the flow. But if I'm speaking clearly enough, even though I'm whispering and covering my microphone, the words that I get up on the screen are very accurate, and it's a great way of being able to take notes without without distracting or having to read handwriting down the track. So for me, the voice recognition software works very well. I think I've also mentioned that I use it in court sometimes as well. And if you use it properly, sometimes when you're summarising or reframing a statement that is made to you, people don't realise that you've actually hit the on button and you're recording what you're saying by way of summary in the written form while you're speaking to someone. So it has that continuity aspect to it as well. All right, now, if there are any questions, yes, there's a question. If you refer to something which you've taken from somewhere else, maybe from a textbook, do you refer to the textbook or do you refer to the original source? My view, always the original source. The fact that the textbook makes reference to the original source is fine, but unless the textbook has added something to it, which you are then referring to, you need not make reference to the textbook. So just the original source. So where do I go for options for words? That was coming back to the redrafting exercise. Just the right click will bring up a lot of things in that regard. Okay, some word about collaborating. It's a really difficult area. You've all done the assessment work, the first assessment, and you're thinking, well, how do I collaborate without breaking the rules? Well, you can plan. You can plan together with your colleagues. You can plan together with your fellow students. As many of you know, I encourage the use of UCrew as a means of exchanging information and ideas, providing each other with tips, links, information guides. All of that is great, and I really do appreciate when people collaborate in a cooperative sense. Collaboration provides an opportunity for you to empathise with your fellow students and your colleagues as well. You know, if someone's struggling, show some empathy, give them a hand. It's all good karma. It'll all come back to you in one way or the other. And as a general rule, and keep this in mind when you're doing group assignment work, aim to give more than you receive. It's a simple philosophy, but if someone is giving a lot, you just aim to give a little bit more than they do. Don't go overboard by any means, but be generous with your time, be generous with your information and your guidance. It will serve you well through your legal careers. If you do have a group assignment down the track, and I hasten to say I actually don't use group assignments, but many of my colleagues do, and you'll need to get used to the group assignment philosophy if you're working in a firm or a government department or wherever it may be. I'd commend to you the group contract pro forma, which you'll find on page 336 of the New Lawyer. And the group contract pro forma is excellent because it provides you with an opportunity to think about how you go about undertaking collaborative work for an assessment piece. Apart from that, I commend to you an extract from Griffith University policy, and it discusses in that policy some guidelines in relation to the matter of assessment. For example, it's perfectly acceptable to discuss with any person issues that have been raised in relation to the work that is being undertaken as a group. And I'm just going to share the screen again so that you can see what I'm talking about. So this is from Griffith University policy, the law school. Discuss with others the issues raised by them in an item of assessment. That's fine. Discuss the possible means by which the issues can be addressed, and collaborate in relation to location or source of materials. All of that's good, and that's exactly what I encouraged in UCrew. What you can't do is you can't work with them in planning the format or the structure of a submission for the assessment item. Now, I'm not talking about a group assessment here. I'm talking about helping your fellow students. You can't collaborate in writing all or part of the student submission for the assessment. You can't collaborate with other students in the writing of all or part of the student's submission, or provide a copy of your work with respect to the assessment. I think all of that's pretty much common sense, really. And as with much of law, if you start to feel a bit uncomfortable, I don't know if I should really do this, it probably means that you shouldn't. But are there any questions about the issues of collaboration? What I encourage you to do and what I tell you you can't do? If there are any questions, it's a good opportunity to do that now. I'll stop sharing the screen for a moment. Okay. And feel free to come back to that at any stage. Now, Chapter 10. Moving on to a completely different topic. Chapter 10 of the New Lawyer. Self-management skills. This is all examinable. I'm really keen on this area of practice, and I want you to work on this throughout your studies. Often I say to people, students, have fun with it. And I really mean that. Do have fun. Enjoy your work. If you wish to be an advocate, which is what I like to do, I enjoy the process of being on my feet, and I work on the basis that I'm trying to help the court genuinely. And that's part of our ethical obligations as lawyers, to understand that Our role is to ultimately, foremost, assist in the administration of justice. So, and you'll be surprised how often magistrates and judges do actually thank you for your contribution. And that's what it is about. So enjoy what you're doing, but keep your mental health under control. Think about your well-being. Now, you will be under pressure. In studying law and practicing law, you'll be under pressure, so prepare for it and embrace it. Have a look at the research findings on page 347 of The New Lawyer. And if you've got your book there, have a look at it now if you wish. But the research findings are really quite staggering and sobering. Depression affects about 1/3 of solicitors and 1 in 5 barristers, according to research. This is 2008, but I'm sure it's still current. That's about 4 times the rate of the rest of the population. So you need to be careful about substances. You need to maintain a healthy lifestyle. So I'd recommend that you read that carefully on page 347. And think about the strategies that you can assist yourself in through self-management in terms of dealing with the pressure that you know you will be under. Some of the strategies that are mentioned in the textbook are excellent. And have a look at page 356 in terms of how you go about the process of determining strategies through reflective practice. This is examinable, so I want you to think about it and do so in your context. Everyone's a bit different. You know, for example, when you're reading a whole lot of material, you're reading a textbook that has multiple materials in it, highlight using yellow pages. Using maybe a yellow highlighter. I use yellow because it doesn't blacken the material if it's ever photocopied. Bit old-fashioned photocopying things these days, but that's why I started using yellow and I've just stuck with it. So, I mean, highlight something so that when it is considered in isolation, it will read as a sentence in its own right. That's what I mean by highlighting selectively. I'm of course looking for an example, but I can't find one as we speak. So if you've got a whole paragraph of words, identify the key words and highlight them so that when you read the highlighting, in itself, that makes sense and it's a complete sentence. Hopefully that makes sense. That is a tip which I want you to practice because it will help you when it comes to the redrafting exercise in the exam. Feedback, page 360. Just bear in mind that the feedback that you receive throughout university and in your working life will not always be positive. Don't take it personally. Take it in your stride. And this is so important. Just please remember the big picture. You might be having a really difficult time. You might have had a horrible phone conversation or a difficult circumstance with a colleague or a client. Just remember the big picture. Resilience, page 362, and this is what it's all about. You need to learn to harness the stress and, to some degree, without being silly about it, adopt a do-it-now attitude. Make sure that you do something to avoid those horrible circumstances that you don't want. Make sure that what I do is for court the next day, I have a particular spot. It's the only spot in my office where I will put files ready for me to collect to take to court. That way I'm pretty confident that everything that I need when I get to court is there. If I have 4 files for a morning's call over and I have 3 of them, you know, and I scatter them all over the desk, it then relies on me remembering which files to take in a hurry. And bear in mind, you've got to be under pressure and the judge isn't interested in your good excuses as to why you're late. The judge just wants you there on time. So that means that you've got to be ready and plan to be ready in circumstances where you're under pressure or something goes wrong. So have a strategy to say, all right, well, I will always put my files for tomorrow's call over in the same spot, and that's all I'll put there. So that if I'm in a situation where I look at my watch and I think, I've got to get to the call over, I've got 10 minutes to go, I will know where to grab my files and go, in the confidence of knowing, okay, I always put the call over of the next matters in that pile and it'll work for me. Someone suggests using a whiteboard. Yep, that's fine. Just got to watch the confidentiality aspect though. If you're using a whiteboard, it's fine in a student context, but maybe not in a practitioner context. And resilience also means prioritising. So have a look at page 362 and have a look at that list. Have a think about what works for you and what you need to consider in that regard. All right, I suppose you'd like some exam tips. The exam's all written, of course. If you consider previous exams, you'll be on the right track. There will be something on separation of powers. There will be something on redrafting legal gobbledygook. Pay some attention to some other issues, judicial activism, which is really linked to separation of powers. Think about the process of taking instructions from a client. You've probably seen from past exams, like situations where you have to pretend that you're now in a first-year law firm. Think about self-management skills. We've talked about that tonight. Undertaking legal research, some skills, but that's mostly going to be in your third assessment, so there may not be a lot in the exam. But being a critical thinker, being an effective communicator, the ethical obligations, that's important. Issues to do with access to justice and administration of justice, that's important. And resilience, I guess, is another issue. So hopefully they're just a few words that you can think of in terms of preparing for the exam. And look, you can write your answers in full if you want. If you think you know what the question is, write your answer. You know what? There'll be something on separation of powers. So if you want to have your take on separation of powers ready to go, great. Bear in mind, of course, that the good thing about open book exams is you can just take anything in, provided you don't have access to the internet. The bad news is that we expect a better standard of work, particularly if I give you a very strong hint that something's on the exam. So you can expect it to be marked to a higher level than if it came as an ambush. All right, now, being committed to justice. There's a lot of ways that the notes don't have to be bound in a form. Thanks, Jazz. There's a question, do the notes have to be bound in a particular form? It's a rule that the student has had in a previous exam. I don't know if you want to elaborate on that, but no, as far as I'm aware, no. But having said that, I don't become involved in the exam process at all. And I haven't had any feedback to say that there have been issues in the recommendations that I've made in the past. So hopefully that will work well. So I don't think there is a form that they need to be bound, that notes need to be in a particular form. All right, so just being committed to justice, a number of different ways. Criminal law, of course, immigration law, human rights law, mental health law, guardianship and administration, some work I do in QCAT. Domestic violence, that's a huge area now. And I'm just mentioning these names, so if you want to start thinking about how you might be able to demonstrate your commitment to administration of justice, one way to do it is to think about a particular area. Environmental law, which I'm very interested in, family law, personal injuries law, anti-discrimination. There are so many different areas where you can say, by practicing in this area, you are demonstrating not only your legal skills, but also showing commitment to justice and administration of justice. So think about what works for you in that regard. Also, it's not just the type of law that might be relevant when considering the administration of justice, but also the way in which the law operates in a real sense. I read a case just today, Judge Dick, District Court Judge, SC, Her Honour made a ruling in relation to a magistrate's order striking out an application, I think, for a domestic violence order in circumstances where His Honour, the presiding magistrate, had requested the applicant file affidavit material in support of the application. Other than what was in the application, which includes some sworn material, the applicant did not, and His Honour the Magistrate struck out the application. On appeal to the District Court, which is a Section 222 appeal, Her Honour, Judge Dick, said that the matter had to go back and be heard before a different magistrate on the basis that the applicant did not obtain a fair hearing, and that the magistrate was entitled to, and in fact obliged, to hear the matter because the applicant had filed some sworn material and that was contained in the application. So when we think about the administration of justice and what is fair, we must always think about, has a person obtained the benefit of a fair hearing? Another thing is, has the person been given the benefit of the ability to test the evidence of their opponent by cross-examination? Is a person treated fairly by being able to refuse questions that might incriminate? I mean, there are some exceptions, ASIO and the Crime and Corruption Commission, but generally speaking, a person is entitled to say, I don't wish to answer that question because to do so will incriminate me in relation to the crimination of a crime. So that's procedural fairness. And placing the burden of proof on a party bringing the action, which is the onus of proof, is also part of the administration of justice in a practical sense. There's also the difference between retributive justice as opposed to restorative justice. Retributive is concerned about how to best punish a person. Restorative justice is concerned about restoring healing to the victim and reintegrating the offender into the community. So if you're talking about the administration of justice in a criminal law sense, you might want to give some thought to whether it's appropriate to look at it from the perspective of retribution or restoration. And then, of course, in terms of access to justice and administration of justice, is the whole issue of, does a particular person or group of people have access to justice? I think it's no secret to say that legal aid funding is very tight. It's very tightly controlled. It's very hard to get legal aid funding. It's not a massive pit of money. So there are, therefore, arguably many people who do not have legal aid funding that really ought to have legal aid funding. There's the whole issue of lawyer-free jurisdictions. Is that fair? Is that a good thing for people, or is that a bad thing for people? And then, of course, when it comes to considering access to justice, there's the whole question of the challenges associated with self-representation. You know, people just don't necessarily have the literacy skills or the familiarity with the process to do a good job. And then there's the issue of costs. If they take somebody on, they may suffer an adverse costs order and have to pay the other side's legal fees. And then, of course, people just aren't familiar with the process. So there's a whole range of things that make it difficult for people to access justice in many ways. All right, I appreciate you've been very patient with me tonight. I've been doing a lot of talking. I propose to wrap it up at that stage. I just invite you to read chapter 10 of the book and chapter 12 of the text carefully as dealing with the tail end of what we've talked about tonight. I appreciate that we should be talking about professional ethical behaviour according to the program. We're 1 week behind, but we might leave that until next week. So your reading for next week is to consider chapter 13 of the text. And also, and this is really important, have a look at the Queensland Law Society website and some excellent material from Stafford Shepherd and his team in relation to ethical behaviour and ethical obligations. That is really important, as of course is the reading of the material from the Law Society, and we'll deal with that next week as well. Okay, so are there any questions? There's one comment, possibility of those already limited in accessing justice becoming limited even more. That's a very valid point. Thank you, Tamara. Okay, well, I might wrap it up for tonight and I'll end the recording now. Thank you.